Hello, everyone. This is um, the Trump versus United States decision. I'm going to move my computer a bit because I'm going to read the notes that I've taken to try to help describe the case and the Supreme Court decision. Okay, so first, the summary/syllabus of the case is as follows. A federal grand jury indicted former President Donald J. Trump on 4 counts that occurred during his presidency following the November 2020 election. The counts allege that Trump conspired to overturn the election through knowingly spreading false claims of election fraud. Trump seeks to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for acts performed within the outer perimeter of his official responsibilities. I really love the phrase outer perimeter. Okay. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. The Constitution has the vesting clause. And third, not all of the president's acts fall within the scope of his job, which questions absolute immunity. As a side note, the court is evaluating the framers' intent of separation of powers. So the framers' presidency is as follows. Official acts. Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be the subject of a subpoena. President Nixon could be served, and the court rejected absolute privilege. There is a threat to criminally prosecuting. There is a threat to criminally prosecute a sitting president, but there is a compelling, quote unquote, public interest in fair and effective law enforcement. Immunity is required to safeguard the independence and effective functioning of the executive branch. Unofficial acts. There is no immunity for unofficial acts. So, point one, no court has declared the difference between an official and unofficial act. A court cannot delve into the difference because it would pose a security risk. The communication, point number two, the communication with other officials makes it harder to see if one was acting in an official capacity. Point three, the executive applied pressure to the Justice Department, even though the executive can decide which crimes to investigate. Point four, the president has responsibility to talk to the public as that falls within the responsibility of the job. Okay, the case does not ask if the comments that a president has needs to be truthful or insightful. It just says responsibility to talk to the public. The case poses the question, when may a former president be prosecuted for official acts taken during his presidency? Now, here's the opinion of the court. Chief Justice Roberts wrote the opinion. The indictment argued that Trump advanced his goal through 5 primary means. As you review these 5 primary means, you have to ask yourself, is it Donald Trump, the president, acting? Or Donald Trump, the candidate, acting? The candidate would not be immune, but the president will be immune. So there's 5 parts. Number 1, he and his co-conspirators, I think it's important to note that Roberts consistently uses co-conspirators. Okay, he and his co-conspirators used knowingly false claims of election fraud to get state legislatures and election officials to change electoral votes. Point 2, Trump and his co-conspirators organized a fraudulent slate of electors in seven targeted states that caused them to submit false certificates to the vice president and other government officials. Point 3, Trump and his co-conspirators attempted to use the Justice Department to conduct sham election crime investigations that would impact the election outcome. Point 4, Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. Point 5, Trump and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification. There's two subpoints to point 5. Number 1, the use of convince leaves the members of Congress open to not taking accountability to do something wrong. And point B, the president's job is to talk to the public. Right. Robert's using of this word co-conspirator while describing the charges, right? This provides this implication of a possible crime as the other members of these indictments did go to jail. So the charges are as follows. 4, conspiracy to defraud the United States, conspiracy to obstruct an official proceeding. 3, obstruction of and attempt to obstruct an official proceeding. And 4, conspiracy against rights. Okay, so Trump argued that all his communication was within his official duties. Both parties then agree that the former president can be subject to criminal prosecution for unofficial acts committed while in office. The phrase outer perimeter of his official responsibilities will describe the lack of protection a president does have. Trump argues that all of his actions were in official capacity, whereas the government argues that some of the actions were official capacities and others were not. The conclusion is that the president does have some immunity from criminal prosecution for official acts before his tenure in office. Section A of the argument explains the powers of Article 2, but the highlight is the president must take care that the laws be faithfully executed. The use of the Youngstown case versus Truman is an example of Truman taking most of the nation's still being legal, as it was in the scope of presidential power. Additionally, the president does have the right to gain pardons and reprieves, such as President Johnson after Lincoln was assassinated, and he pardoned former civil rights veterans and generals. There is limited restrictions Congress can place over presidential power. So there are limits with this. Roberts asserts that the courts and Congress have limitations on observing the president's power within the constitutional authority. The courts cannot examine a presidential action. Therefore, presidents are absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Section B. The president must make far-reaching and sensitive decisions. So the president must have immunity in order to fully execute presidential decisions. Yet when prosecutors are seeking information from the president, then this can be permitted. The examples of this happening are former President Aaron Burr and the Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subject to subpoena. Similarly, Nixon had to comply with a subpoena, but a president must be able to speak with candor to high-ranking officials. This means there is a fundamental right to have executive privilege. but this privilege is related to a president's power. They are not deciding in this case if a current sitting president can be open to criminal prosecution. I think that's an important point. They're only talking about former presidents. Section C is highlighting that presidential and official acts do not have immunity. This is held with Clinton versus Jones, which allowed Clinton to testify and be open to a lawsuit surrounding non-presidential acts. The separation of powers does not protect a president from prosecution of non-presidential acts. Even though a president is not immune to have a president charged, experience a trial, and criminal proceedings will distort presidential decision-making. Thus, a president is more likely to experience civil damages versus criminal proceedings. Yet, it is in the public interest to have effective law enforcement. This entire case hinges on the idea of what did Trump do as a private citizen versus being the president. This will be very difficult because there are discretionary responsibilities the president does have. The government explains that Trump was utilizing this role as president to influence his co-conspirators and to try to influence others. The executive also has the exclusive authority and absolute discretion to decide what to investigate and what not to investigate. Because Trump can discuss anything with the Justice Department, he cannot be prosecuted for discussions with the Justice Department. The president and vice president should be in close discussions because it is part of their job and their responsibilities. Therefore, their discussion should not be considered official acts and responsibilities. Therefore, their discussion should be considered official acts, right? Their discussions and interactions with state officials and election officials in Arizona, Georgia, Michigan, Pennsylvania, and Wisconsin need to be reviewed. If they followed the president's directives, then they would have been committing a crime with submitting fraudulent votes. Trump asserts that this interaction was official because he wants to ensure the integrity and proper administration of the federal election. The president also has broad power to speak on matters of public concern, such as election integrity. Yet, the government sees these actions as being a private scheme with private actors. The court states that they do not have enough information to make a determination, so they will revert the decision to the lower district court. So, Trump talking to the vice president, the Justice Department, about whatever they want to talk about is an official act. Trump talking to state officials, even though it's about public concern, that is still an unofficial act because the federal government has no control over elections. So there is no true reason for a president to interact with state representatives that, which would be your Secretary of State, over various elections. Therefore, because therefore the Supreme Court stipulated that the lower court's ruling stands. So the first 3 counts threw out, but it's going to be these last 2 accounts that they lend back to the lower courts, how he talks to the public and how he talks to state and elected officials are both going to be on the lower court, and the lower courts found Donald Trump acting outside of unofficial duties, and therefore he does not have immunity from those 2 areas. So Trump addressing the crowds through tweets and public address. They do not have the fact-founding process to address this issue as well, right? So this means, again, as I stated before, that the lower court, district court, is going to have to review this. So the concept of having a jury trial does protect individuals, but it does not protect the presidency. This is another point of contention, because even Justice Barnett and the Sotomayor, Kagan, and Jackson all disagree in saying that a jury trial does actually protect everyone, including the president. An impeachment is a political process, so merging it with the criminal proceedings has little support within the United States Constitution. We have never had a president who faced criminal charges ever. The nation's documents and practice has been silent on this. The dissent is focused on hypotheticals and the fear of future acts if a president feels empowered to violate the federal criminal law. Ultimately, when can a president be prosecuted for official acts taken during the presidency? Never. The president does not have immunity during non-official acts. So Justice Thomas was concurring. Criminally prosecuting a former president for official acts is a threat to our constitutional order. Thus, the Constitution does not permit this. Thomas is writing separately to highlight how this prosecution may violate our constitutional structure. There is a question on if the special counsel is constitutional, as the president cannot create offices at his pleasure. Therefore, the special counsel cannot create a criminal prosecution when the existence is non-constitutional. This is a rich perspective, as this has not been questioned with Nixon and Clinton. Creating a special counsel without Congress creating it provides the president with too much power. Thus, Congress must be conscious that the special counsel should be in consensus that the special counsel should be appointed. Allowing the Attorney General to create a special counsel may be outside the purview of constitutional authority. This needs to be addressed in order to ensure that the president could be prosecuted for non-official acts. So first off, essentially, if the existence of a special counsel is unconstitutional, then the special counsel cannot bring any type of charges to the president or any other. This is interesting because this comes into question even with Justice Thomas. There's a call for Thomas to be investigated through a special counsel as well. Okay. I will say, if you read Thomas's decisions, then you will notice how he is definitely unique. In his perspective, that is really largely weak in structuring his justifications. Okay, Justice Barrett concurring in part because she does not join Part 2C of the court's opinion. There should be certain legal issues that are addressed before going to trial. The president's constitutional protection is narrow. Right, the president has no authority over state legislatures or their leadership, so it is hard to see how prosecuting the president for crimes committed when dealing with the Arizona House would intrude House Speaker would intrude on executive power. It is not good policy to evaluate the constitutionality of prosecuting a president after the case has been tried. The case should be tried before it goes to court, literally evaluating the constitutionality of it going to court. Barrett agrees with the dissent as the president should be prosecuted for breaking the law and there should be grand jury to review the case. If the grand jury finds merit, then it should go before a jury case. The Constitution does not isolate the president from criminal liability of official acts. Okay, so Justice Sotomayor dissent with Kagan. Granting the president immunity reshapes the presidency. The question is if the president enjoys complete immunity from prosecution. Reviewing the indictment demonstrates that the core constitutional powers are expanded. The Constitution is silent on criminally prosecuting a president. The Constitution does not protect presidential immunity. The example is Reagan-Iran Contra scandal. The expansion of immunity is more vast than the Constitution and Trump's lawyers. A president should go through the criminal proceedings, and if there is a question of constitutionality, then this should be heard through an appeals process. If someone is going after a president maliciously, then it would not make it through the legal process. Sotomayor and Kagan are asserting that you cannot evaluate this case through official and non-official acts because you have to evaluate intent. President Trump's intent is to thwart a campaign. Therefore, he was breaking the law. Official and unofficial acts must be lawful. The president cannot treat the Attorney General and the Justice Department as a personal legal outlet. This quote really stands out. Let the president violate the law. Let him exploit the trappings of the office of personal gain. Let him use official power for evil means, for evil ends. Justice Jackson dissented as she agreed with Sotomayor as a matter of history and tradition, logic, and law. Jackson is writing because she wants to explain how the majority has altered the paradigm of accountability for presidents of the United States and what this all means for our nation moving forward. A defendant has constitutional rights to defend themselves and to have a trial. There are opportunities to reveal if the charges should be dismissed. Theoretically, if a crime is an official act, then there is a level of immunity from criminal prosecution and punishment. Hypothetically, a president could order the assassination of a political rival or critics with complete immunity if the order is considered an official act. This new power, presidential accountability model that authorizes the judiciary to exempt presidents from punishment under the law, increases presidential power and opens it to presidential abuse of power. Our government was designed to have a separation of powers and restrictions on each branch of government. Creating a president with absolute power creates chaos and tyranny. Traditionally, the government has relied on the law to keep the president in line. I'm not sure how much I agree with this concept Jackson is making, because it appears the threat of impeachment kept the president from breaking the law. And as we know, impeachment is a political act. Thus, it could be public opinion and political will that has kept the president from breaking the law, as that is what kept the president accountable.